Welcome to this week's episode of Chaile Time. Toby, welcome, and how are you?
Tsepo, are you still working for us? I haven't seen you like in 2 weeks.
Sometimes.
Eh?
Sometimes I'm here, sometimes I'm tired, I'm exhausted.
Tell us a bit about your schedule the last 2 weeks. I've literally not seen you. This is the first morning in like 2 weeks. I've been to KZN and back, and this is the first morning I see you.
Yeah, Monday I drove to the Val. Tuesday I started at CCMA Johannesburg at 9 in the morning, finished at 17:25.
Ooh, that commission is claiming overtime, eh? They normally leave at 3 or something.
Wednesday I drove to Tabazimbi. The place is hot. From Tabazimbi then to Northam. From Northam back to Pretoria, you can imagine.
But the other day you did the hearing report until like 2, 3 in the morning.
In between, remember now.
You said you slept on your desk or something.
In between, remember now, I still have pending things that I still have to give reports to the clients. So in between there, I have to.
I shame, Chaile. I spoke to a company, I think it was yesterday, yeah. They had like 4 IR managers who already resigned. So the person told me that the IR manager, when he resigned, said, if you want to be an IR manager, you can't have a heart, man. It is tough. It's tough. You can't have a life and you can't have a heart. So I told her, no. At least we have a big heart. I just don't have nails. My nails are finished.
Because you keep on biting them. Yeah, but what are you talking about? I remember when I was still at logistics. At 3 a.m., I'll be up on my phone. I will know each and every truck, where it is, who's the driver in the truck, where are they going, when are they going to be back in Gauteng, and those kind of things. And then around 5, I take another 1 hour nap. 6 o'clock, I get ready for work. So when I get to work, I already know how my day looks, starting from 4 in the morning. So some people are not willing to pay that price, I want to wake up at 7, 8 o'clock I'm at the office, 4 o'clock I'm going home. That's not how it works, especially in that, industry.
4 o'clock is a new 5, no?
4 o'clock is a new 5.
Don't they say 9 to 5? It's 9 to 4.
No, it's 8 to 4 now. It's nice.
So one day it's not 9 to 3 and then 9 to 2 and then government just give us for free money.
Yeah,
we don't work at all anymore.
That's it.
But anyway, we are talking about a bit of a contentious issue. Disputes about rights and disputes about mutual interest. Tsepo, you had a conciliation, I think it was like a week or so ago.
Yeah. What, 2 weeks ago?
Yeah, what happened there? It was a conciliation.
Yes.
It was only a conciliation.
We had a union claiming that the HR department or managers or whatever, I don't know which part of the structure, it's putting their members under an enormous pressure whereby it's like they're putting a trap for them to be fired, they are victimizing them,
And isn't that normal? People always complain about this.
And the commissioner kept on saying, but if you are fired or dismissed, let me not use the word fired, if you are dismissed unfairly, the law still protects you.
This is America, this is not Trump, né?
Okay. The law.
The apprentice of Donald Trump, he always said you're fired, né? And then years ago, at the time when he had his apprentice shows, this is something extra. Mr. Chaile, he also had like an apprentice.
The local one, yeah.
And it was so interesting when he fired the people, he said, you dismissed. So proudly South African.
Yeah, so they will be like, now we need those people. Okay, there was a grievance against one of the managers.
The grievance was, the manager must be suspended and be removed, something like that.
Something like that. But it was established now at the council that, no, this grievance was sorted, and then the people who brought the grievance against the manager agreed that it is sorted. But now later, the unions, it's still sticking on that issue, but they say they want changes in the company.
So there was a grievance submitted?
Yes.
Against a certain manager?
Yes.
I believe that manager got like a warning.
A final written warning.
Yeah, I think it's because of the way he speaks. He swears
and whatever.
So the manager got a final written warning. And then
There was another one against
staff,
someone.
I think it was fine, but the union wasn't fine.
Yeah, the
so
union
then
wasn't
they
fine.
referred a matter of mutual interest dispute
Yeah.
to the bargaining council.
Yeah. Claiming that if things are not going to be changed in the company, if now they were complaining about the manager, the HR person, and the third person, I think the director, they have to be put on special leave up until an investigation is done, and then those people mustn't be in contact with any of the staff members. Then my first question was that, what about the operations of the business? But they didn't care about that. And then if that is not going to happen, then they will embark on a strike, blah, 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 blah.
But you see, this is now what we're going to talk about today. Again, a bit of a dotted line to jurisdictional matters. We're talking about, in this context now, a dispute of right and interest. And I've got a interesting judgment here from the Constitutional Court. But one of the elements that, that we raised was this whole issue of jurisdiction,
Yes.
okay? Arising out of Section 65, subsection 1 of the Labour Relations Act. Now, a bit of a background. Section 64 of the Labour Relations Act basically provides for the right for employees to go on a strike. The procedure on how to embark on a protected strike. But Section 65, one of the sub-provisions there provides that if a matter or a dispute can be arbitrated or adjudicated, okay, then employees can't go on a strike. And this is where this whole debacle is coming from, the difference between the dispute of interest and the dispute of mutual interest, and whether you can go on a strike on disputes of rights. But a bit of a lesson here, Tsepo, is that when sometimes we think of jurisdiction, we think of the CCMA or the bargaining council having or lacking jurisdiction. We sometimes forget about the processes. Now, just the fact that the CCMA or the bargaining council may not necessarily have jurisdiction to arbitrate does not mean they can't conciliate.
Yeah.
And I think this is one of the lessons that came out of this conciliation also. Because in terms of Section 186, subsection 2, okay, what deals with unfair labor practices, it's well known that an employee who submits a grievance and is not resolved to his or her satisfaction can refer that dispute for arbitration at, let's say, the CCMA or the bargaining council, depending on the jurisdiction. So in this case, because the employee submitted a grievance and it was dealt with, but they were not happy with the final warning, I think, they wanted the manager fired or dismissed.
Trump.
They wanted this. How some of the brothers, the comrades, they can be so demanding,
Yeah.
You must dismiss the manager, but don't dismiss my members.
Yes.
And then they wanted the independent committee to be established, to investigate the manager. But I'm like, do we form committees whenever your members must be dismissed? You see, there's only one set of rules. No?
Yeah.
It's their rules.
It's their rules.
But anyway, so and this is the problem sometimes. We think of the bargaining council and the CCMA and say, you don't have jurisdiction because you can't arbitrate this matter. Then we think they don't have jurisdiction to conciliate the matter. So, interesting in terms of the Constitutional Court case. We're just going to go through it's a 2017 case. So it is fairly recent. Constitutional Court, Department of Home Affairs versus the Public Service Association. In this case, the employer wanted to bring forth and amend shifts, like your starting and finishing times on a daily basis or whatever the case may be, which the company or the employer feels is a prerogative of the employer. But the staff and the unions did not agree. So they filed a dispute of mutual interest to the bargaining council. And this is where this whole debacle coming from. And the representatives, the legal representatives of the employer also went to the council and said, you don't have jurisdiction. Because, once again, we fall in that trap. And in this case, the judge actually clarified this matter quite nicely. Just the fact that a institute forum like the bargaining council may not have jurisdiction to arbitrate does not mean it does not have the jurisdiction to conciliate. Because conciliation, in essence, is a without prejudice process. It's an informal process. It's a process whereby people talk to see if you can't resolve a dispute amicably without having to go either on a strike or arbitration or adjudication, the labor court or so forth. But now interesting is, and this is where the problem is coming in for HR managers, business owners and legal professionals, because the LRA actually does not define a dispute of right and a dispute of mutual interest. There's nothing in this book that say, mutual interest disputes or disputes of rights. Let me read section 65, subsection 1C quickly. No person may take part in a strike or in a lockout or in any conduct in contemplation or furtherance of a strike or a lockout. Then it mentions A, B, but let's focus on C. If the issue in dispute is one that the party has a right to refer to arbitration or to the labor court in terms of this act, it doesn't mention dispute of right. It just say if a party has a right to resolve dispute arbitration, then you can't go on a strike. But that doesn't mean a commissioner can't conciliate a dispute. So, in terms of the Constitutional Court, let's see quickly how they address this matter. The bottom line here is this. Disputes about matters of mutual interest refer to conciliation must be conciliated, be they rights or interest disputes. It is not the function of the conciliator to pronounce on whether the dispute is one of rights or one of interest. So what they are basically saying is that any dispute that arises out of a contract of employment is a matter of mutual interest, keeping in mind that mutual interest is not a matter defined in law. So we're using the phrase mutual interest dispute in a very generalized term. So I suppose, if you give somebody a warning, that's a matter of a mutual interest between parties. Yeah. Whether it's a matter of a grievance or a salary increase, all these kind of disputes are in essence a dispute of interest between people. There's no legal definition attached to that phrase in terms of the law.
And actually, in that very same case that you are talking about, this is the route or the direction that the commissioner took on that day.
But the commissioner is right.
Yes.
Because you must remember, before that commissioner, there are no mutual interest or disputes of rights. There's just a law. There's a dispute here. And anyway, if a union or employee party wants to go on a strike, to go through the protected means in terms of section 64, you need to file for conciliation, okay? But there's also a time limit. So if the commission, they say the CCMA, don't set the matter down for conciliation after that time limit, then the union can go on a strike anyway, regardless of whether this process was conciliated or not.
Or not.
So practically what the court is also saying, given this fact, the union ticked the box in the application form, mutual interest dispute. If the CCMA, or in this case the bargaining council, did not set the matter down for conciliation, they could have gone on strike anyway. But the issue then is whether the dispute would be, or that strike would be protected or not. But that's a separate issue. And there, Section 65(1) will come in, whether the actual dispute could have been arbitrated or not.
Yeah, because
but that's a separate issue.
Yeah, she kept on saying to the union person, saying, you keep on saying you are going to embark on a strike and you're going to that people are going to starve, people are not going to get paid for that. And then it doesn't seem like those people that you are representing, they are aware of the decision that you want to make now. And also, you don't want to narrow down the issues. What is actually the core of the issue?
What's that about? I believe he couldn't tell us.
No, he couldn't tell. He said, no. He said something like, he quoted also a case law of Metropolis versus something back in the days, that if you don't want to disclose your issues, then you don't have to.
So you have somebody here filing a mutual interest dispute.
Yes, but he doesn't want
grievances, but doesn't want to tell you what the grievances are.
He doesn't even have an instruction from employees saying, okay, these are the issues. Let's look at these issues if we can resolve them or not. So he was very vague. And then he kept on screaming, and then I was so relaxed and chilled. But I would ask him one question. I say, I hear what you're saying, but can you at least give us one or two things that we have to look into? Because you said you want managers to be put on special leave, suspended, work from home, don't come nearer to your members and stuff. But what are the issues? Because the grievance is resolved. The other person whom they complained against, he resigned. So we don't have a problem here. Tell us the new problem that we have to focus on, knowing that when we appoint the neutral person to come and investigate, we know where we're heading with this. But he kept on saying, no, I'm not going to tell you. Then the commissioner's like, why are we here now?
Tell us about the committee.
Now it was agreed upon that now they're going to be a neutral person appointed to come and investigate. And then the question was, who's going to pay for that person? Then it's like, yeah, if you're going to have to go 50-50 with the company, and then we will. I've got a list of law firms that we can look into and appoint someone there. Then we went for a caucus, and then, we left him there. When we come back, we're like, okay, it's fine. We will pay 50-50 for the neutral person to come in.
Who said that?
The company.
The company.
Yeah, the company said, no, we will pay 50-50. We are willing to pay our 50%. The union must pay 50%. And I was like, Commissioner, maybe this can be resolved. Let's just extend the conciliation and then see. How many days do we have? The commissioner is like 30 days. So it's too much. Maybe this matter can be resolved. Then I'm like, in my heart, I'm like, he didn't get the instruction to come and pull that stunt.
He was speaking out of his turn.
He didn't. No company will want to give out money just for. And those lawyers, they don't come cheap. Ne? They don't come.
No, they don't. You see, Timber, this is a power play. We are the union, we want members, we're playing politics. You see, it's this power game, and we're going to show the employer who we are, whatever. But there's no case there. But anyway, so they filed a mutual interest dispute, and obviously the idea is to go on a strike, I suppose. But there is actually no grievance has been resolved.
Yeah.
But in essence, the grievance. Now remember, any dispute is in essence a mutual interest dispute. You can file it for conciliation. Whether you can go on strike is a separate issue. But in this case now, because it seems like the primary issue is the grievance against the manager, which was resolved.
Actually,
that dispute can be resolved through arbitration in terms of Section 186, subsection 2, the unfair labor practice regime.
Yeah, it actually takes me back to the one grievance that I handled, and someone said they were not happy, and you tried to intervene, and they were still not happy, and then it went hoo-ha. It went to the CCMA, and then in the CCMA, the commissioner tried to find what is the problem, and then the person was just trying to quote 177 pages of. Apparently, she resigned.
Yeah, she resigned this week.
Yeah.
Anyway, let's continue. What constitutes a matter of mutual interest is not defined in the LRA. The term serves to define the legitimate scope of matters that may form the subject of collective agreements, matters which may be referred to the statutory dispute resolution mechanisms, and matters which may legitimately form the subject of a strike or a lockout. Interest and rights disputes are both matters of mutual interest. Remember, this term is used in a general way, a general form, because it's not defined in the law. So what the court is saying, in essence, all disputes are, I suppose, mutual interest disputes, okay? This matter deals with reference of a dispute about a matter of mutual interest to conciliation. Conciliation. Whether the matter is a dispute of interest or right, and therefore whether it may legitimately form the subject of a strike, is not relevant for the determination of whether it may trigger conciliation under the LRA. So you can't say CCMA or Bargaining Council don't have jurisdiction. You must say maybe they don't have jurisdiction at arbitration, or maybe the employees don't have the right to go on a protected strike because of this matter can be arbitrated. It is the failure to make this distinction that led the Council After the Department of Home Affairs and in turn the conciliator at the bargaining council was tried. Interesting is the commissioner agreed with the employer in this regard, but it was later overruled by the Labour Court and hence it went all the way to the Constitutional Court. The court continues, disputes about matters of mutual interest may be referred to conciliation by a commissioner or a bargaining council under the LRA. Work practices and their alteration, like the shifts, what the employer wanted to bring about, by management lay at the heart of employment relationships, and the dispute about them would certainly qualify as matters of mutual interest, capable of being referred to conciliation under the LRA. The court then went on to declare that the bargaining council conciliator had jurisdiction to conciliate the matter before him. Then, the submission, the LRA does not speak of rights disputes or interest disputes. A strike about a matter of mutual interest that the party has a right to refer to arbitration or to the Labour Court under section 65(1)(c) of the LRA may not necessarily be protected. Okay? But whether it falls within that limitation neither defines the jurisdiction of a conciliator under the Act, nor does it prevent a conciliator from attempting conciliation of the disputed dispute. Her function is to attempt conciliation, and if that fails, to certify that the dispute had not been resolved. After the expiry of the statutory conciliation period, unions would have been entitled to strike, even if the certification was not forthcoming. So what I'm basically saying here is that the bargaining council had the jurisdiction to conciliate. Her job in terms of conciliation was really just to issue a certificate if it was not resolved, to say that it's not resolved, it remains unresolved, or I suppose if it was resolved, there would have been some form of settlement agreement. That's it. Section 65 speaks about arbitration and adjudication.
Yeah.
Now, if the staff and the unions went on a strike, whether that was protected or not, that's a different conversation.
Yeah, but we took 30 days, you see.
Now, 30 days is a timeline.
We're going to resolve that issue, don't worry. We took 30 days and then the issue is going to get resolved.
Yeah, but Chepo, no, I have another issue. We have a similar case we're dealing with. Staff who wants to, the employer wants to change shifts.
Oh.
No?
Yes.
You already had a meeting with the staff and the staff says no.
Yeah, they said no.
You know what came out now? The staff have other work. I've got other work at other places they also do.
Did they disclose?
No. We only find it out now because remember you gave them a deadline until Wednesday, which was 2 days ago.
Yes.
To raise their representations as to why the employer should not change. But in that case, the employer paying them full salaries, but they're not working their 45 hours on average per month, much less. So actually the employer is shooting themselves in the foot. And the staff, it came out now, was opportunistic. They took the extra hours and days and now found other alternative employment.
And then they have a system of manipulating leave.
Yes, and the manipulating leave
They're
also.
manipulating leave. And I saw that whole process. And then I drew a bigger picture to them. And I was like, you are also being unfair to
the employer.
To the employer. Because remember now, this is a two-way street. I kept on emphasizing on a two-way street thing, whereby this person renders a service and this person makes sure that you get compensated for the services that you are rendering. But here it seems like now the road is one way. Because first thing that they raised was like, my comfort. I'm like,
yeah, because the employer now, all they want is the staff to start working their 45 hours per week, but which will also result in them being able to cut some staff. This is an NPO, okay? So they're dependent on sponsorships and government funding. So they can obviously cut back on a bit of employees too if they can increase their shifts. But now the staff, yes, they're kicking against it. Mutual interest or dispute of rights, Mr. Kanama?
I'll see when I get there. I'm going back there soon.
Yeah, we need to make an appointment. They're waiting, yeah. Anyway, that's for this week.
Thank you for watching.
Before you say goodbye, any parting comment?
Any
parting comment?
No, I don't have any parting comment.
You always have something to say. Hey?
No, I don't have anything to say. I'm tired.
Ach, niemand. I told you I had a meeting the other day at a new client. Eh? Oh, this we were talking about it today. It was for a new company. They phoned us out of the blue. You know what they told me? When I had a meeting with them yesterday to see if we can get more business. No, they want Tsepo to be seconded there every day of the week.
That's why my question was, who is Tsepo? Seriously, that was my first question I asked. Who is Tsepo? I don't want to sit in a position where I'm hated by 200 people, odd people again, because
they are gonna hate you. That's how it works.
Because you are sitting with white people. That's how they say it actually. You are sitting there surrounded by white people. You are the only black person sitting there surrounded by white people. So I don't know that situation.
White monopoly capitalist.
But are they making an offer, a good one, for me to go and sit there for them? Heart attack.
I said no, it's not going to happen. So we'll do business in a different way.
Thanks for watching. Don't forget to like and subscribe. Put your comments so that we can also take your views into consideration. Bye.
Bye.